The next case is Commissaris van Binnenlandse Inkomste versus Transvaalse Suikerkorporasie. There are two reported cases, so don't get them mixed up. I'm now dealing with the 47 SATC 34. And what is important about this particular case is, reading from the head note, is that this case since 1985 is a precedent for giving taxpayers the opportunity to approach the special court for hearing income tax appeals where the commissioner has exercised a discretion or his decision, and that decision is not specifically made subject to objection and appeal in one of the taxing statutes. You'll recall that in going through the Income Tax Act or the VAT Act, many of the decisions or the conduct taken up by the Commissioner and his officials are specifically made subject to objection and appeal. And it's very important to remember where it is specifically subject to objection and appeal. In terms of Section 7 of the Promotion of Administrative Justice Act, or PAJA, you are obliged to exhaust all internal remedies. Now, taking the matter on objection, then through the appeal process in the tax court, is one of those internal remedies that must be satisfied, and you cannot just simply go to the High Court in terms of the provisions of Section 6 of PAJA. Otherwise, you'll find that the Commissioner's legal team will have your case thrown out of court on a technicality and a procedural technicality for that purpose. However, if you are, for instance, wanting to tackle the discretion or decision of the Commissioner that is not specifically subject to objection and appeal, such as, for instance, the investigative powers of the Commissioner in terms of Section 74A and 74B of the Income Tax Act, or 57A or 57B of the VAT Act, well, there it's not specifically made subject to objection and appeal. That means you can test the conduct of the Commissioner against Section 7 of PAJA, and you wouldn't be falling foul of Section 7, which says you must exhaust all internal remedies, which means you have to go the objection and appeal route first. You can, in effect, go directly to the High Court, except Transvaalse Suikerkorporasie really now is precedent for the possibility for you to argue, well, instead of going to the High Court, I'd like to go to the Special Court for hearing income tax appeals anyway. Why would you want to do that? Well, let's just quickly look at the pros and cons. High Court is a much speedier route. You can get to court much faster. Problem is you're going to be faced potentially with a judge who is not a specialist, does not have specialist knowledge in tax, so that's not necessarily a good thing. If you go to the special court, you will have a judge that knows something about tax sitting with a business and accounting assessor, so there are three people to hear your case, and they will be skilled in that matter, or at least relatively skilled in hearing the matter. Problem with the special court is that it takes a long time, and the court role, unfortunately, is under the control of the Commissioner, which is a bit of a one-sided affair, and it's not in the hands of an independent judiciary. So that does cause some concern. The Commissioner says they act fairly, but unfortunately, we've seen in practice that they tend to push their own cases of interest and let others fall by the wayside, and one hopes that will not continue into the future. You can, of course, bring an application along the lines of what you would do in the High Court in the Special Court. It is not something that has happened often. I think there are only a handful of these applications that have been brought, and unfortunately you are somewhat at the beck and call of the registrar of that court, who is under the control of the Commission, as I've said before. So it just means that the timing might not be as speedy as going to the High Court. And you may want to go to the High Court if you've got a particularly strong case and you think that there is a good chance that the legal team of SARS at the time of receiving your application may be prepared to sit round a negotiation table and try and negotiate the matter off the table. But that's not always the best place to be. But anyway, that's what the importance of Transvaalse Suikerkorporasie is. Where there is no objection and appeal process that is made applicable to the discretion of the Commissioner, you can still use the procedure of taking the Commissioner on review in terms of the grounds set out in Section 6, and you would effectively now have an election or you can, what they call forum shopping. You can either go the High Court route, or you could end up going to the special court. That's all on this short lecture. Until next time, goodbye.